Imagine having a job where just one wrong word, one casual comment, could completely blow up a case, get you sued, or even end your career. Well, that's the daily reality for a probation officer. Today, we're going to walk a mile, or maybe just a day, in their shoes to really get a feel for the incredible pressure of keeping things confidential.
All right, so let's start with something that probably happens all the time. You're a probation officer, you're off the clock, you're with your friends, and you know they're curious. They want to hear about the crazy cases. So can you share a story? As long as you don't use any names. Seems harmless enough, doesn't it?
Picture it. You're at lunch, just trying to decompress, and a friend leans in and asks for a good story. You think, okay, no names, no problem. But right there, that's the very first legal trap of the day.
And the answer is a hard no. It might seem overly cautious, but even without a name, if you give enough details, the neighborhood, the type of crime, some unique facts about the case, you run a huge risk of what the law calls indirect identification. Somebody could easily connect the dots, and bam, just like that, you've breached your most fundamental duty.
And that duty is called confidentiality. And you got to understand, this isn't just some company policy. This is a massive legal and ethical pillar of the job. It's a probation officer's absolute obligation to guard sensitive information, and it's so important it's even tied to constitutional rights to privacy. It's a really big deal.
Now, this is where things can get a little confusing, because people often mix up confidentiality with privilege, but they are not the same thing. Think of it like this. Confidentiality is the big, broad fence the officer has to build around all client information. Privilege, on the other hand, is like a special key to a very specific room, like conversations with a lawyer. And here's the kicker. The client holds that key, not the officer.
Okay, so that handles the danger of just a casual chat. But back at the office, the challenges get a lot more official. Next up, deciding who gets to actually peek inside the case files.
So an email dings in your inbox. It's from a school counselor. They know one of their students is on your caseload, and they're asking for information because they want to help support them. I mean, their heart is in the right place, for sure. But this request puts you right back on that legal tightrope, especially when you're talking about a kid.
So who actually gets a backstage pass to a juvenile's file? Let's do a little lightning round here. How about the defense attorney?
What about that school official who means so well?
A reporter sniffing around for a story?
And what about another police department or law enforcement agency? Do they just get a free pass?
Okay, here are the answers. And you can see access to juvenile records is incredibly locked down. That's because the whole point of the juvenile system is rehabilitation, not creating a lifelong label. So attorneys, school officials, they need a judge to sign off on it. Journalists, almost never. It's really only other law enforcement agencies who can get access, and only for official business. The main takeaway here, the default answer is always no, unless a specific law or a judge says yes.
All right, let's fast forward to the afternoon. You're in a meeting with an adult on your caseload, and they bring up a word that is packed with some of the most common and, frankly, dangerous misunderstandings out there.
They lean forward and say, "Hey, good news, my old case was expunged. That means it's gone, right? Like I never have to mention it again?" This is one of the most misunderstood ideas in the entire justice system, and the way you answer this has to be spot on.
So here's the absolute crucial difference. Expungement for an adult is not the same thing as having a juvenile record sealed. When a juvenile record is sealed, it's pretty much treated as if it never happened. Access is almost impossible. But expungement? That's more like having the conviction dismissed. The guilty plea is withdrawn, but it doesn't just vanish into thin air.
And that difference is so important. An expunged record isn't invisible. It's still right there for law enforcement to see. It can pop up on background checks for certain professional licenses or government jobs. Telling someone their record is gone is just plain wrong, and it could cause them to lie on a super important application down the road.
And now we've reached the end of the day, and with it, the single most high-stakes, gut-wrenching decision an officer has to make. This is the moment where the duty of confidentiality slams head-on into a rule that is even more powerful.
A young person on your caseload is just talking to you, maybe about their week, and in the middle of it all, they casually mention something that sets off every alarm bell in your head, something that sounds like abuse or neglect at home. And then they look you right in the eye and say, "Please, you can't tell anyone." They've just put all their trust in you.
But in that instant,
their plea for you to keep their secret becomes totally irrelevant, because that one statement has just triggered the officer's absolute non-negotiable duty as a mandated reporter. There is no gray area here. There's no choice to be made.
The law on this, specifically the Child Abuse and Neglect Reporting Act, is crystal clear. It's a simple two-step command. First, you make an immediate phone call to Child Protective Services or the police. You don't need proof, just reasonable suspicion. Second, you have to follow that up with a full written report within 36 hours.
So, how many choices does an officer have in this situation? One. That's it. You report. Every single time. It overrules the client's wishes, it overrules the general duty of confidentiality, it overrules everything. And failing to do so isn't just an ethical misstep, it's a crime.
So, after a day like that, a day just packed with legal landmines and ethical dilemmas, how does an officer possibly navigate it all? Well, it all comes down to a few core guiding principles.
This is basically the survival playbook. The golden rule, number 1, is if you have any doubt at all, don't disclose. Just don't. Second, write everything down. Document your decisions and why you made them. And maybe most important of all, consult. Talk to your supervisor, check your agency's policies. You never have to walk this tightrope alone.
And that really is what it all boils down to. For a probation officer, the hard part isn't knowing the facts of a case. I mean, the facts are all sitting right there in a file. The real test, the constant day in and day out challenge, is knowing whether or not you are legally and ethically allowed to share them.